Zaldivia versus Reyes Jr. GR number 102342, July 3, 1992. This is for criminal procedure, specifically on criminal actions, how instituted. Question: what is the effect of the institution of the criminal action? Answer: the institution of the criminal action shall interrupt the running of the period of prescription of the offense charged unless otherwise provided in special laws. What is the rule on prescription in case of institution of a criminal action based on special penal laws? Prescriptive period for special laws is interrupted by the institution of proceedings for preliminary investigation. Cases falling under the rule on summary procedure covers violations of municipal or city ordinances which shall be filed directly in court without a prior preliminary examination or preliminary investigation. Thus, the case shall be deemed commenced only when it is filed in court, whether or not the prosecution decides to conduct a preliminary investigation. This means that the running of the prescriptive period shall be halted on the date the case is actually filed in court and not on any date before that. Facts of the case. This case was about the applicability of the rule on summary procedure in specifying the prescriptive period for violations of municipal ordinances. This was an original case for quarrying for commercial purposes without a mayor's permit in violation of a municipal ordinance in Rodriguez Rizal, allegedly committed by petitioner Luz M. Zaldivia on May 11, 1990. Hence, the police referred the complaint to the Office of the Provincial Prosecutor on May 30, 1990. On October 2, 1990, an information was filed by the Office of the Provincial Prosecutor be- before the MTC in Rodriguez Rizal. At the MTC, the petitioner filed a motion to quash the information against her on the ground that the crime had prescribed. However, said motion was denied. The petitioner's appeal before the regional trial court was also denied by the respondent judge. On appeal before the Supreme Court via petition for review on certiorari, the petitioner argued that charge against her is governed by the provisions of the Rule on Summary Procedure and Act Number 3326. She maintained that the information was beyond the 2 month statutory period from the date of the alleged commission of the offense. Hence, the charge against her should have been dismissed on the ground of prescription. On the other hand, the respondent countered that the prescriptive period was suspended upon the filing of the complaint against her with the Office of the Provincial Prosecutor. The Office of the Solicitor General further argued that Section 1, Rule 110 of the 1985 Rules on Criminal Procedures applies to all cases without distinction, including those falling under the Rule on Summary Procedure. The Supreme Court granted the petition and dismissed the case before the Municipal Trial Court on the ground of prescription. Issue: whether the offense charged against the petitioner had already prescribed. Ruling: yes, the offense charged against the petitioner had already prescribed. The Supreme Court said that the rule on summary procedure covers violations of municipal or city ordinances. Furthermore, Section 9 of said rule provides that the complaint or information shall be filed directly in court without need of a prior preliminary examination or preliminary investigation. Thus, the case shall be deemed commenced only when it is filed in court, whether or not the prosecution decides to conduct a preliminary investigation. This means that the running of the prescriptive period shall be halted on the date the case is actually filed in court and not on any date before that. In this case, the offense charged was for violation of a municipal ordinance which shall prescribe after 2 months and for which the penalty cannot exceed 6 months. Therefore, it was covered by the rule on summary procedure. Hence, the Supreme Court said that the prescriptive period for the crime imputed to the petitioner commenced from its alleged commission on May 11, 1990, and ended 2 months thereafter on July 11, 1990, in accordance with Section 1 of Act Number 3326. It was not interrupted by the filing of the complaint with the Office of the Provincial Prosecutor on May 30, 1990, as this was not a judicial proceeding. The judicial proceeding that could have interrupted the period was the filing of the information with the Municipal Trial Court of Rodriguez, but this was done only on October 2, 1990, after the crime had already prescribed. Therefore, the offense charged against the petitioner had already prescribed. In applying the foregoing, the petition was granted and the case before the municipal trial court was dismissed on the ground of prescription.